So Robby, what's on your radar?
Well, last week marked the 50th anniversary of a very important and not well understood law that is called Title IX. So you may have heard of it. If so, you probably know it as the law that requires sex and gender-based equality in public education. Its original purpose, going back to the 1970s, the time of its adoption, was to ensure that no woman was denied a spot in a school, the right to start a club, participate in a sport because of her sex. It's important, well-intended law. Women did face rampant sexism in all sectors of society, and education was no different. Now, how well the law actually fared in achieving equality, I think, is up for debate. My colleague at Reason Magazine, Natalie Dowzicki, wrote that Title IX did remove barriers for women and girls to participate in sports, but the implementation has been flawed with worse outcomes than anticipated. Now, obviously, the transgender sports debate is directly related to Title IX, and Rising Friday's host Emily Jashinsky talked about some of that in her radar on Friday. But I want to talk about a different aspect of Title IX, a curious one that dates back to actually just the Obama administration, a little more than a decade ago. The Education Department did something I think was truly bizarre. The administration's Education Department interpreted Title IX, this gender equality statute, as requiring university administrators to treat sexual misconduct and harassment as forms of sex-based discrimination and investigate all accusations on college campuses frequently with a zealousness that often sacrificed principles of basic fairness. Under Catherine Lehman, who was the Obama administration's Title IX enforcer, colleges increasingly moved to a single investigator model in which one administrator would investigate a claim of sexual misconduct, determine which witnesses to interview, and produce a report asserting guilt or innocence. Accused students were routinely denied access to legal counsel, awareness of the charges against them, and the ability to cross-examine their accusers and their witnesses. Hundreds of students, most of them men, not all of them, but most of them, were sanctioned by an educational institution attempting to comply with the Obama administration's interpretation of Title IX. These sanctions were frequently challenged in court, and then many such students ultimately prevailed due to the underlying unfairness and the quasi-legality of these Kafkaesque proceedings. For many, however, relief comes far too late to resuscitate their college careers. Quote, Title IX is supposed to ensure fairness for both parties in campus sexual assault adjudication and not solely the accuser, says Casey Johnson, who's a history professor at Brooklyn College and expert on this type of trial. Unfortunately, however, as applied, Title IX too often has been used as a sword to erode principles of due process and prevent wrongly accused students from having a meaningful chance to defend themselves, end quote. So under former President Donald Trump, Education Secretary Betsy DeVos revised many of these the guidelines relating to Title IX in order to create protocols that were fairer for both parties, the accuser and the accused. Now, the DeVos reforms underwent formal rulemaking procedures which gave accused students the right to consult legal counsel, have legal counsel scrutinize the narratives of the accused. The rules also allowed for non-adversarial restorative justice options in cases where both parties prefer this option. Sounds normal, right? Shouldn't someone accused of something have access to legal counsel, have the right to actually be aware of the charges against them without a single administrator deciding this entire thing on their own? That's basic kind of due process, basic justice. It was gone during the Obama administration. It was brought back by Betsy DeVos. But now, President Joe Biden has vowed to undo the reforms. Last week, on the 50th anniversary of Title IX, he took the first steps toward actually accomplishing that. Education Secretary Miguel Cardona proposed a series of revisions to the Education Department's Title IX approach that would gut due process protections embedded in the DeVos model. Cardona's proposal would once again permit adjudication via a single investigator, denying accused students the right to challenge their accusers. Schools would no longer need to hold hearings at all. They would instead be interrogating individuals during individual meetings, which they might not fully understand the nature of the accusation. So I want to go over the 5 ways this guidance is actually changing the landscape for this kind of trial. First, definition of sexual harassment is being broadened. The DeVos rule had established 2 types of sexual harassment: quid pro quo harassment, which is where an individual asks for sexual favors in exchange for employment or some other favor, and then also unwelcome conduct. Now, quid pro quo harassment only had to occur once to count as harassment, but unwelcome conduct harassment had to be so severe, pervasive, and objectively offensive that it denies a person equal access to their education. That's a definition comes straight out of case law. Davis versus Monroe County Board of Education is the relevant decision. So that was the DeVos standard. The new rules, the bar is much lower. Cardona would define unwelcome conduct harassment as conduct that is sufficiently severe or pervasive, not severe and pervasive, that based on the totality of the circumstances, evaluated subjectively and objectively, denies or limits a person's ability to participate in their education. Subjectively. Could be subjective. So opens the doors to Title IX investigations of speech that is sexual in nature and subjectively offensive to another person without it needing to be severe and pervasive. The free speech implications are significant. Legitimate classroom speech that was subjectively offensive and occurred repeatedly could now become a matter for the campus Title IX cop. Now, second, schools no longer need to provide hearings for accused students to cross-examine each other, as I alluded to. One of the most fundamental improvements of the DeVos rules was the establishment of cross-examination. Representative for the accused student, such as an attorney, had the right to scrutinize the claims made during this kind of adjudication. Under the new rules, no longer the case. Third, the single investigator model, as I said, is back. Instead, colleges and universities may once again use this model, which, just to be clear about what it is, a single administrator questions various parties privately, reaches a conclusion about the underlying guilt, often without any sort of hearing taking place. The new rules assert that investigators may engage in individual meetings with the parties, where the parties never interact with each other at all. Fourth, accused students aren't guaranteed access to the evidence against them. They aren't guaranteed even to any of access to the evidence against them. Under the DeVos rules, both the accused and their accusers were entitled to inspect and review any evidence obtained as part of the investigation. Not so under the new rules. Parties will only be guaranteed access to a description of the relevant evidence, and this description need not be written down. Administrators can provide it orally or in writing. Fifth, university personnel would be required to report suspected sexual misconduct even if the purported victim opposes this. The DeVos rules clarified that post-secondary educators were not required to report suspected sexual misconduct following several cases, Title IX investigations that occurred despite the supposed victim's contention that she had not suffered misconduct. A university official cannot declare someone a victim. That person, the alleged victim, must initiate the investigation. Under the old rules, under the new rules, not so. The Department of Education's proposed regulations seek to erase essential due process protections that are required by the department's current Title IX regulations. That's according to Joe Cohn, who is Legislative and Policy Director at the Foundation for Individual Rights and Expression. He says that they authorize institutions to forego live hearings, return to the single investigator model, and it's incompatible with basic fairness and basic requirements of fairness. This is a war on basic fairness in college. It's a war on due process. It's a war, let's be clear, essentially on men, given that the overwhelming majority of young people whose lives were ruined due to these bad Title IX rules are men. And that's what's gone wrong with Title IX in general. 50 years after this law became the law of the land, the statute is being used not to expand educational opportunities, but to narrow them for students who are accused of sexual misconduct and then subjected to blatantly unfair processes. And the progress made in the last few years toward reestablishing fairness, justice-based hearings on campuses, that's being undone as we speak by Joe Biden. So I've done a lot of reporting. This is a longer radar for me than usual because I've previously done a lot of reporting on these rules that were very, the previous rules, the Obama rules, were very bad on due process grounds. Like if you're accused of something, you should have the right to defend yourself. You should have a basic presumption of innocence. You should have an attorney. You know, you fight for these things, right? You know.
And I was about to say we're in alignment. We're in alignment, actually. I think listening to that, you see a reflection of what our criminal system is in general. A lot of our criminal system is that prosecutors moving forward with cases despite that the complainants or who they're deeming victims have said, no, I don't want this case or this didn't happen. I'm not a victim, and they do it anyway. So I want to point out that this egregious level of due process violation you're hearing in these laws does reflect our larger criminal system. And so I do wonder whether or not generally, not in your case, Robby, but whether or not people's pushback to it that they don't have for the criminal system in general might be that a lot of the people most impacted by this on college campuses are white men, as opposed to the black men that are victims in the criminal system. But I do agree. I think, listen, I understand. I understand. I completely credit and sympathize with the reality that most people, and usually women that are victims of sexual assault or sexual misconduct in this country, do not have it taken seriously or have it legitimized or do not feel like they can reach out in the criminal system. But I think there is a dangerous problem of overcorrecting, right? On one end, you have, okay, they never listen to women or the criminal system doesn't, respond well to sexual misconduct or rape or these things. But you can't have a system in place that does the extreme opposite, that doesn't, because these are grave allegations, right? I wouldn't even just just say it's ruining someone's life in terms of just their college career. I think in general, because if people have been found, what people will think, and they'll say, oh, you've been accused, you've been found guilty of sexual misconduct. Yeah, they didn't take it criminally or what happened, but that will stick with you in the same way. So I do think
ruins your job prospects. It puts you in debt.
Your social circle.
A lot of these people, took out student loans and now can't ever get a degree. You can't pay it off until you get the degree. Now you can't pay it at all.
I think very often when it comes to, I have this conversation a lot in my spaces because, I'm an abolitionist, I'm anti-carceral, and very often I find that people who also say they're anti-carceral, their response is to create social systems or systems in other areas of our life
pretty darn punitive.
that act the same way and carry out the same results. I think it's very important that you always have to have a process where you interrogate anything. Even if I wanted to say on the majority of times, oh, they probably did. I think there are a lot more things that are sexual misconduct or exploitative or messed up that happen in terms of people's interpersonal relationships and all these things that we know or account for. So I recognize what they want to do in theory, but you can't just accuse people. It's absurd. They need, I think in a situation, I don't even think it's just, a lawyer should be able to, push back a little bit or hear it or scrutinize it. I think if you're making accusations against somebody, they need the full accusations. They need exactly what they're saying. They need a lawyer. They need a cross-examination. This is very serious, because if you think about it, right, in the criminal world, a lot of what is punished on college campuses aren't and can't be really punished criminally. A lot of things that, language would be thrown out. There would be far less consequences in the criminal system, but yet here we have this college system and I've taken your education, your future. I think it's just too serious, regardless of whether or not you feel in terms of right, wrong, this and the next thing, and the larger implications for society. At the end of the day, we can't have this large system in place that just completely railroads.
Under these new rules, they're gonna a single administrator is gonna call you in an office, say, sorry, you were accused of, what is it again? It's not gonna be written down. They're gonna just say it, and then based on what you say in that, you're gonna be like, what?
Right.
And then they go, okay, so denied it. Okay, well, I think they're guilty. That's gonna be the whole. That could be under these new rules, the whole procedure, which is insane.
And it is insane, and that's why I want to make sure I point out everyone that's hearing it and thinks it's insane. The criminal system does move like that. They move like that. They submit you evidence of something. It's all redacted. You don't know what's happening. You can't actually get the paperwork. Your clients have no idea why they're there. They've arrested people. So in the same way this strikes you as fundamentally unfair, remember this the next time I'm telling you about the criminal system. I agree, Robby.
That's great. Well, thank you very much for that. And we will have more Rising in just a minute.